seat, everyone. This is cause number 21-200-662-2140 Hart versus Sandra Perkins, who's the auditor of Skagit County. Mr. Hart, are you with us today? Can you hear me okay, sir?
Yeah, I can hear you fine, Your Honor.
Good afternoon. Mr. Peterson, can you hear me as well?
Good afternoon.
So
yes, I can hear you.
Thank you. Mr. Hart, we're here on your motion for an order to show cause. We're here for the show cause hearing today. I've had a chance to review all the written materials. I've also been provided by court administration a thumb drive that came in an envelope, presumably from you, that there are 4 videos on that. I've had an opportunity to review those. For me to review those, for these to be part of the record, we'll have to admit those as an exhibit. I'm going to have those marked. I'm going to hand it to the court clerk. It'll be identified as exhibit number 1. You do have a right, sir, after this is marked, once any appeal period has run, to request that you can come retrieve this if you wish. Otherwise, you can direct the clerk just to destroy it. What would be your preference?
I'll retrieve it.
Sorry, Matt Clerk, so I'm handing that to the clerk. That'll be marked as exhibit number 1. I'm going to fill out a form, Mr. Hart, in that regard before we go today about you wanting to retrieve that. We're going to mark it right now. Mr. Hart, I assume that you provided a copy of that to the state?
Yes, Your Honor.
Mr. Peterson, I assume you had a chance to review that since you made transcripts of it and attached that, responded to that.
Yes, I did, Your Honor.
Mr. Hart, I assume you want that admitted as evidence in the case for the court to consider?
Yes, Your Honor.
Mr. Peterson, do you have any response in that regard?
We have no objection to the court's consideration of the first video as it pertains to Mr. Hart's general election request for his replacement ballot. We would request, however, that Mr. Hart identify the date and approximate time that he made the request, either under oath or some form of acknowledgement of that. We would object to the court's consideration of the primary request by election request by Mr. Hart. At least that's what's designated, because we consider that's not relevant to the general election. And those 2 individuals who, the 2 videos which are labeled informants without the identity of the date and time that those incidents occurred, we believe those constitute hearsay and should not be considered by the court.
Mr. Hart, do you want to respond to that?
Yeah, as far as the general election, the date and time, if I can attest to that now, that was Tuesday afternoon at the auditor's office. And then in regards to the primary...
I assume on the election day?
On election day, that's correct.
Okay.
And then as far as the primary, the evidence is provided to show the consistent procedures and practices of the auditor's office. They directly pertain to the general election because they show that this is not a single isolated event. And the dates and times of that can be the actual ballot verification, I believe, is visually identifiable in the video to be this year's primary. So I dispute that there is any real challenge that it's relevant, and also that there is not information adequately already provided in the video to establish that it is the election office in this primary.
Anything else, Mr. Peterson?
No, specifically with respect to the 2 individuals, we have no date and time that those incidents occurred, and at which primary it may or may not have been. These are representations by Mr. Hart, which there's no statements under oath which support when and who the individuals were.
Your Honor, there's been no statements in those videos necessary to obtain a ballot to vote in an election. I don't know why they would ask for it now.
Well, because we're not submitting a ballot, sir. You're presenting evidence in a courtroom. So here's what I'm going to do. Obviously, I'm going to admit exhibit number 1 because all the videos are on in the same thumb drive, folks. All to give due consideration to the videos. It's clear that I believe, if I'm not mistaken, Mr. Hart is your argument is that no signatures were required at the time those ballots were requested?
I'd say that's a fact, actually, but I would say my argument is the videos provide video evidence of the actual primary being this year's primary. That's actually video evidence in the video. So to be disputing what they're seeing before your own eyes seems kind of silly. I've been contacted, and just to be clear, I was provided those videos as an independent reporter. The informants, I let them know that they were being used and concealed their identity, as I agreed to when I initially published the videos. And so I'm hesitant because they're fearful of retaliation for providing that evidence on how to proceed with it. However, if the court mandates it and it's willing to provide some sort of written protection for those informants, they have told me that they would be willing to provide more information.
Well, let's hear the argument first, and then I'll decide upon the admissibility of those later, the latter two exhibits by the individuals identified by you as an informant. So why don't we hear the arguments first, and then that'll help me make a determination about the admissibility of those two. So, Mr. Hart, it's your request.
Sure. And thank you, by the way, for guiding me in how you speak. I do appreciate it. I'm not that fluent in this process. So as you're aware, Your Honor, I contacted the court in my attempt to bring the court's attention to what I understand to be wrongful acts and omissions occurring in the ballot replacement process for the current election, and my request that they be immediately addressed. In the declaration of the court, I informed you of the video recordings that you've already referenced, and that they contained evidence illegal ballot replacement. The videos, again, there's one of me personally in the general election, one of me personally in the primary. I can attest to both of those, the date and time. If I don't think I did so for the primary yet, but I can get that date and time for you. When you review the videos, you can confirm, the court can confirm, there is no verification that the person requesting the replacement ballot is a registered voter themselves. Secondarily, there's no verification that the person requesting the ballot has the legal authority to possess that specific ballot. Two distinct elements there. I think it's important to point out to the court the registered voter verification requirements, RCW 29A.08.010. To begin, it is very clearly outlined that for the initial ballot to be issued to anyone in this state, in this county specifically, there's information that has to be provided to the election office. And it includes and if I didn't, make sure I didn't misstate it, 29A.08.010, name, residential address, date of birth, and a signature attesting to the truth of the information provided. The legislature is very clear that is what's required to be issued out a ballot. And the auditor has no authority to issue that ballot until that information is provided. Moving on, the legislature also was very clear about the critical importance of verifying that the ballot is only provided to those who have legal authority to possess it. I will point the court to statutes 29A.84.410. Understand that this states any person who is retained by any officer authorized by the laws of the state to procure the printing of any official ballot or who is engaged in printing official ballots is guilty of a gross misdemeanor if the person knowingly gives or delivers any official ballot to or permits any official ballot to be taken by any person other than the officer authorized by law to receive it. The legislature created another similar criminal statute for the possession as well. And that is under RCW 29A.84.540. And that one is ballots removing from voting center or ballot drop locations. I'll remind the court the video is of the ballot at a voting center. It is involving the printing of ballots. And this statute makes it very clear any person who without lawful authority removes a ballot from a voting center or ballot drop box location is guilty of a Class C felony. The legislature could not have been any clearer that the possession of the ballot is a critical item, and only those legally entitled to possess that ballot should be provided the ballot. The voting centers have the obligation and requirement to maintain that chain of custody for the ballot. I will point to I'll remind the court of the original statute that was issued in my declaration to the court, 29A.40.070. It is very clear a registered voter may obtain a replacement ballot. The law could not be any clearer. It does not say anyone who feels like getting it, anyone who comes in and asks for it, but it must be a registered voter can get a replacement ballot. The WAC, it's very interesting to me that the auditor's office would like to use the WAC 434-250-080 in trying to substantiate their actions, but they seem to have conveniently overlooked straightforward language in that WAC. And I'll read that to the court, that if a voter appears in person at a county auditor's office before 8 p.m. election day and requests a ballot, I'll remind the court that is exactly what I did and that the video evidence confirms. The county auditor must determine if the voter is registered to vote in Washington. I will remind the court that the video substantiates the standard practice as in shown in all videos. There is no verification. And I think it's important the court consider that when people are requesting replacement ballots and the personnel at the auditor's office are simply asking what ballot they want, that's not verifying anything. That is asking people who come in off the street, what ballot should we give you? Verification. The legislature provided the auditor's office the responsibility to verify ballots at multiple levels. I've already mentioned that the ballot issuance must be verified through a signature affidavit, and that's why in my initial declaration to the court, I felt the law was very straightforward and clear. I'll remind the court that the statute for voter registration clearly states that all information other than the name, address, date of birth, and the signature affidavit is ancillary. It doesn't matter. It just doesn't matter. That is what matters. The legislature made it very clear. So I've read these statutes. I'm aware of them, and I know the auditor's office is aware of them. They know the WAC exists, and they must determine if a voter is a registered voter. I'll point out that in RCW 29A.40.160 states in Section 9, the county auditor shall require any person desiring to vote at a voting center to either sign a ballot declaration or provide identification. I think I've up to 4 now places in legislation that outline a consistent instruction for the auditor at voting centers specifically to sign a ballot declaration and provide identification. The signature on the declaration must be compared to the signature on the voter registration. This is the auditor's responsibility. The legislature has allotted a significant budget for signature verifications at auditor offices. The instructions from the legislature is to mandate signature affidavits for ballot materials. And these videos, as someone who was firsthand witness to them on multiple occasions and provided the informant videos, has identified to the court that the auditor is neglecting their obligation to ensure the possession of the ballots are only those lawfully authorized. They're neglecting their legislated budget authority to use signature verification on any ballot material. It's all been put in place. They're just refusing to do it. And that is why I brought this to the court, because it's so obvious to everyone. And I'm a common person. This should not be happening. The legislature, again, I don't think it could be any clearer. I'll also point out to something that's very troubling, and I'm still kind of scratching my head about it, and that's the statements made in my declaration about the invalidation process. And I'll remind the court, and specifically on the statements from the election offices that are trained and under the supervision of the auditor, they are informing those who go in for replacement ballots that the prior ballots will be invalidated. I'll tell you what that does as a voter, and everyone who I've spoken with thinks the exact same thing. That alleviates all monitoring requirement of me to make sure somebody has not submitted a ballot improperly, or there was a technical error counting my ballot before mine replacement ballot is counted. Which, again, this is a self-monitored system. Up to this point, nobody has figured out this is what the auditor has been doing to the voters of Skagit County. I happen to figure this item out, but the invalidation, misrepresenting the law on that, because, and I'll point this out to the court, if I understood it correctly, in their own response to the initial affidavit, the auditor in response said that my statement that the initial ballot is invalidated is absolutely incorrect. They stated that they're lying to people in these videos. They confirmed it. I'm not even sure what's going on right now, to be honest with you, but I know that they're not consistent. They're making false statements according to their own legal responses to the court. They're confirming that. And combined with the issuance of ballots in a way that seems to just be grossly negligent in their oversight authority of that ballot possession and signature verification. Again, I come back to why I'm here in front of the court. We need to fix this. I'm asking for the court's assistance to correctly identify what the voters who have had replacement ballots should have been told, if they actually had their initial ballots invalidated or not. I don't still think the court even knows. I don't think between statements made by their employees directly to the voter and then now statements made by them in their legal case, I don't really know what's going on. But either way, the voters of this county should know, because there are provisions in the statutes for the voters to look into and see if their ballot was properly counted or not. And right now, I don't know how many voters in this county were told that their ballot that was originally issued was invalidated. If that's true, I've seen preliminary data from the election office that is almost 2,000 ballots somehow, and that wasn't even a final count. I assume all of those people have been informed incorrectly, and they are waiting for the outcome of this election without the knowledge that they should monitor the status of what happened with their replacement ballot. So that point I'm very frustrated with, because I really don't know if the court knows or the auditor's office knows what's going on there. The misstatements are themselves improper, but yeah, I will focus primarily on the replacement process itself, Your Honor. The statute seemed clear, the evidence seems clear, and that's why I don't know how you couldn't consider all of the videos, because they show the consistent pattern that this is not a one-time event. This is how it has been operating in that office, and this is what the voters of the county understand to be the replacement ballot process.
Are you finished?
Yeah, go ahead.
I want to make sure you're finished.
Yeah, go ahead.
Well, thank you, Mr. Hart. Tell me this, that what should I see? I saw on the videos that I watched previously that of what the auditor, assistant auditor, or whoever that person was representing the county at the time, was telling people, you know, what ballot's correct, what isn't, and which ballot's going to be valid. What are you telling me that they should have been told, as opposed to what was on the ballot? That's
a great, and I actually have the answer to that. I'll point you out to what the process in the legislature already has, and that's under the voting center laws and the statute. Just for reference, I'll get it in front of me here, and it's one that we've already noted. Okay, bear with me. I'll open it up. Voting centers, RCW 29A.40.160.
Not so fast.
That's
Can you repeat me again?
Yeah, RCW 29A.40.160. I would say the legislature has given us just absolute point-by-point instructions for this exact parallel in the provisional ballot, which is a very parallel, it's equivalent to basically a twin of this situation. And the statute gives the exact procedure. And I'll read that to you here.
But just to be clear for the record, what section of that statute are you reading from?
And I'm going to get, it's a larger statute. My eyes are trying to find the section. I believe it is 10. And let me read it quickly. Yes. Provisional ballots must be accompanied by a declaration, again, a signed affidavit, and security envelope as required by, and a space for the voter's name, date of birth, and current and former registered address. Reason for the provisional ballot. This would be very much a replacement ballot, and actually further in the statute, they actually give the description in this process that this could be a second ballot issued that shouldn't be counted. And disposition of the provisional ballot. The voter shall vote and retain the provisional ballot at the voting center. The voter must be provided information on how to ascertain whether the provisional ballot was counted and, if applicable, the reason why the vote was not counted. So throughout this entire section, I think there's another subsection here that even clarifies it more for you, Your Honor. Bear with me. Okay, signature. Yes, it's again. I might be. This does. I'll emphasize. This does begin to address it. And my eyes are having a hard time casting it right now. But it does say the voter must be provided information on how to ascertain whether the provisional ballot was counted. So this goes back to the confusion of the invalidation, Your Honor. Through the WAC, I think they referenced WAC 434-250-080. It talks about replacement ballots in here as well. And the county shall reissue a new ballot when the registered voter has taken action to update their voter registration. So I'm on the third. They don't have a subsection in this one. They assign as well in this WAC a procedure. And I'm trying to find it here. Yeah. I on the spot here, I don't want to make you have to wait too long, Your Honor. I wasn't prepared for that question other than knowing that it's in here. It does represent under the provisional ballot provisions that the voter be provided the actual instructions on how to determine it. That is the auditor's responsibility, by the way. That's not mine. The auditor needs to provide that instruction on how to determine if that ballot has been counted or not. And that I'd say that in itself is the direct response. It should be something that the auditor can quickly respond to.
So you think under the statute there's a difference between replacement ballots and provisional ballots?
You know, I reread that over and over. It's a little blurry to me. I see the difference in the two that I keep seeing is the inference that a provisional ballot potentially could be somebody who isn't legally registered already in the county. They're generally treated the same in procedures, and I think that's important to acknowledge that these procedures are parallel. The concepts between the two are parallel as well.
So you believe what the auditor was telling you and the others on the videos where that the ballot that they handed to you, the replacement one, was now the ballot that would be counted and you destroy the other ones? Do you have any difficulty with that?
Well, if I heard you correctly, I absolutely have difficulty with that. Your Honor, they said that's not what happens. That's what the record, their response stated. That original ballot, I can answer this very, very directly, Your Honor. As a voter, this happened to me. This is what I showed you video of. I had thought my original ballot, which I misplaced, would be invalidated. I voted, but I could have, my original ballot could have been counted. That's what I understand the law is. It is actually the first signed ballot that's received and accepted. Well, knowing that they had two ballots out there that could be counted in my behalf, I would, and every other voter would be monitoring what's going on at that office much more closely to make sure we could challenge the ballots that were received. That process is outlined in the statutes as well, but because the auditor's office directly told me that previous ballot would be invalidated, which was false, I no longer looked. I thought, well, it doesn't matter now. I don't have any reason to monitor what's going on. And that is one of the major flaws in that invalidation statement is it's misleading a system that the legislature has enabled the public to monitor from believing it doesn't have to be monitored anymore.
Okay. Anything else you want to tell me, sir?
I don't want to speak off cuff here too much. I did have no, I think I've hit it. I'm more than happy to answer questions on it, but again, Your Honor, I'm not the only one that feels this way, and I've seen the numbers on this. The auditor's office is unable to provide me with the final number of replacement ballots because of the status of this election. When I went in last week, this is somewhere between 1,000 and 2,000 votes in a county election where many positions are only a dozen, dozens, not 100, not 500, and I think we're easily exceeding that. So I'd like to just stress to you and the court the significance of this and the significance that the video proves that the voters out there didn't know what was going on. They were informed incorrectly, and they're not allowed to monitor any of this, which it's critical to our election system.
Okay, well, I'll come back to you. I'm going to hear from Mr. Peterson, and it's your motion today, so you're going to have the final word in a reply, Mr. Hart. So,
okay,
Mr. Peterson, go ahead.
Thank you, Your Honor. At the outset, I want to point out the position that the auditor has with respect to provisional ballots. That's different. Provisional ballots have their own specific definition. They are entirely different from replacement ballots. RCW 29A 04008 contains specific definition of a provisional ballot, which is a ballot issued to a voter who would otherwise be denied an opportunity to vote for any reason authorized under the Help of America Vote Act, including but not limited to the voter's name does not appear on the list of registered voters. There's indication of voter registration that the voter has already voted in that primary, special, or general election, but the voter wishes to vote again. There's a question on the part of the voter concerning the issues or candidates on which the voter is qualified to vote. In other words, they think they may be in the wrong area, or any other reason allowed by law for provisional ballot. These are not provisional ballots. These are replacement ballots requested by the voter to obtain. And what evidence do you have, Your Honor? The replacement ballots actually, the definition or how those come about are under RCW 29A400703, which says a registered voter may obtain a replacement ballot if the ballot is destroyed, spoiled, lost, or not received by the voter. I had some troubling concerns now regarding the statements by Mr. Hart during the course of this hearing, where he thought he had voted already and now is requesting to vote again. He didn't come to the auditor's office asking that question. He came asking for a replacement ballot after apparently he claims he already voted, or now states he already voted. So I have some concerns about the nature of the issues he's raising. But what you have is the voter asking for their own ballot. A voter asking for their own ballot is specifically provided for by that statute. And in addition, the WAC 434-250-080, which has the force of law.
Give me that again, will ya? Give me the WAC, your cited again.
That's the one in our brief, and it's actually the finding 13 on the order. That's 434-250-080. Says the auditor shall issue a replacement ballot as authorized by the statute I just mentioned if the request is received by the prior to 8 p.m. on election day. This has no provision for where that request is made or when it's made. It could be done 2 weeks beforehand if your dog ate your ballot. This is allowed at any time. It doesn't just happen on election day. And it goes on to state, requests may be made in person, in writing, by telephone, or electronically by the voter, a family member, or registered domestic partner. How are any of those other individuals going to provide a signature of the voter themselves? Mr. Hart is conflating the requirement for verification of the signature that occurs initially on for a voter under 29-08-010. This is not that situation where we have a voter who is initially registering. This is a registered voter who comes in and asks for their replacement. And so what you have is Mr. Hart, who's entitled to ask for his own, got that. Apparently he did that in the primary as well. And so there's nothing illicit or wrong in the process of giving the voter who represents that he's that person his own vote, his own ballot to vote. And that's what occurred here. So we don't have any violation of either of the RCW or the WAC. And I'm at a loss to understand what Mr. Hart is really expecting to do when you request a ballot. There's no requirement in here for a signature of the person who's making a request. And that the individuals that I named who can make a request do not include the voter themselves. And this is important because in the end, that initial registration that provides for the signature of the voter at initial registration is then compared with the declaration on the outside of the exterior envelope that's provided to the court, to the auditor with the vote. So you compare the two to make sure it's the same individual, and that's the process that we go through in every election. So regardless of whether the vote, Mr. Hart seems to suggest, and again, we don't have any evidence that Mr. Hart has shown us that anybody other than the registered voter has voted in the election of Skagit County. We only have Mr. Hart claiming, I didn't understand the process, or I didn't understand which of my votes counted. Well, he wasn't there to ask the question about whether or not which of his votes counted. He was asking there to get a replacement ballot. And my point about whether or not the court should consider the primary versus the general election, you will know, the issue that Mr. Hart complains about the auditor making a misstatement as to which ballot is invalidated. And I'll clarify this to the court. It's, as I said, initially in my response, and as Mr. Hart is represented here, the initial ballot received, regardless of whether it's the initial ballot that was sent out or the replacement ballot which is requested by the voter, the first of those two, which is received by the auditor and counted to vote, is the ballot that counts. And so the auditor in the primary apparently misspoke and said that the ballot was invalidated. Well, I think there's kind of a bit of confusion here because the person is questioning because they don't have the ballot. Well, the person is trying to put the mind of the person at ease, saying, "Well, we don't worry about being counted." In that way, yes, it was a misstatement. Again, that was in the primary. There's no evidence that occurred with respect to the general election because we provided a transcript to the court, and you'll see in there is no representation as to which of the two is invalidated. And the WACs are clear that it's the first vote which was received by the auditor is the one that counts. And of course, with the signature verification, if the first one doesn't have an incorrect signature verification on it, comparing the signature of the initial voter registration to the one that's on the ballot that's received in the outer envelope, then that would be rejected. But we don't have any evidence that's true. We don't have evidence with respect to Mr. Hart's individual situation. So from what we have, that Mr. Hart's requested, which is requirement for signature verification of the voter at the time the request for a replacement ballot is made to the auditor, is simply not a requirement of the RCW's or back.
Mr. Peterson, you think that RCW 29A 4000703, which I think we're focusing on here partly, does that require the county auditor to some affirmative duty to verify somehow that this person is the registered voter?
It doesn't require, well, if you see verify the register, no, it doesn't. It doesn't say verify in the language of the statute. It allows you to do the request by telephone, by mail, or electronically or in person. So how can you do a telephonic verification of the person when your initial voter registration, referring to the initial statute that Mr. Hart pointed to, 29A 08010, there's not going to be any information that's going to be not available to the general public on that initial information that will allow anything other than a telephonically to verify the individual. So the statute as written provides methods by which a signature verification is not required, and that would explain why our Attorney General has provided the WAC, which is the force of law, which allows other individuals to make that request on behalf of the voter. Because what we're talking about here is trying to encourage and make sure that valid votes are counted. The comparison of the signature on the initial registration to the one that's on the ballot received is the protection that's available here, and why this whole issue really is a non-issue, because the replacement ballot, if it's issued to the wrong person, will not have a signature that matches. But we don't even have that here. Mr. Hart asked for his own ballot, he got it, and apparently he was able to vote. So we're glad he's concerned about the system and that he voted.
Yeah, two more questions. One is Mr. Hart is concerned that somebody comes in and get a replacement ballot. He's claiming it could be somebody else walking up, signs votes, that gets sent into the department. It's received before his actual, say, his original ballot that he would have received in the mail, and concerned that his ballot that he submitted won't get counted. Are you telling me it's the signature verification under the system that is the protective mechanism in that scenario?
That certainly is a protective mechanism, and you're trying to force on to do some other system and force on the auditor something which is not set up by the WAC or the RCW to require, because a telephonic or email request would not have that type of verification either. But in the end, yes, the protection that we have is comparison of the initial voter registration to the signature that's on the ballot, on the outside of the envelope of the ballot that's received.
So on the video that I've seen, and that were part of exhibit number 1, that I haven't admitted yet formally, but let's say the one with Mr. Hart in this past general election, that it appears that before a ballot's handed to him, a replacement ballot's handed him, the assistant auditor is asking for name, address, maybe date of birth, some other information. Is she looking on the computer, do you know, Mr. Peterson? Is she looking there to see that he's already a registered voter?
Well, that's a good question, Your Honor, and actually she can't issue a ballot to the person till the person's a registered voter, because the ballot is specific to the location and address where the individual is. So with the ballot that's printed is one that's reflective of the jurisdiction we're at, because if he's in Cedar Woolley, he's not going to get an anacortes ballot which has anacortes braces on it, because that can't get run through the system. So yes, she's looking at, I mean, I'm speaking out a matter which is not a part of the record, and you know, I'm loath to do that. Mr. Hart made a bunch of representations as to the numbers of replacement ballots, and that's outside the record. but I'm answering the court's question. You can actually see her looking at a computer screen when she's typing the information. So in that regard, I suppose it isn't part of the record. But logically, she can't issue a ballot unless she has that information about the individual. And that's why the person is representing to an election official. He's that person. And the election official can rely on that.
Well, that's what from what I gathered from the video, part of what I gathered from the video is the process that Mr. Hart and the others went through. But from the auditor's perspective, she's asking for that information. There's no way that she could provide an accurate replacement ballot because of the various different jurisdictions you may be voting on without him or her being already in the system as a registered voter. She wouldn't have been able to print a ballot for him, would she have?
No, she wouldn't have. And Your Honor, if you need confirmation of that, I may have an auditor official who could appear and address that matter.
Yeah.
Can I speak to that, Your Honor?
Mr. Hart, you get a chance to reply.
Okay. Well, I'll start with the last part, and I'll go back to where this started off. This discussion I've been hearing between both of you, I would just point out to you that this video, first off, in the primary, shows the auditor asking the person requesting it if they still live at a certain address, and they name that address. That's not asking for the address. That's telling them the address. That's video evidence and proven. The signature verification process, it's laughable that I just heard that conversation happen. Telephonic requests, the ballot request, replacement ballot request process is clear. You can request it. Well, you can also vote via email across the entire planet with a signature verification requirement that the auditor has to still verify. Your Honor, I would point out to the court that it is very convenient that they would like to omit that they do this on a regular basis. This is what they have been legislated. Tens of thousands of dollars to enact in the voting center is the ability to do voter signature verifications through affidavits. They have a co-signing process as well for people who are unable to sign by themselves. The process that we are talking about is the exact same process that votes are approved to begin with. There's nothing different. It's in place and they do it every day, and they would like to fool the court and trick the court into believing it never happens, and it's never been done. In reality, in the last election, it was done over tens of thousands of times. They will put them under oath and ask them. They take remote affidavits all the time from people. So I don't consider that a reasonable request, and I would hope the court would laugh at them for it. I would secondarily point out the difference between a request over the phone that would send the possession of a voter ballot that will potentially be used in an election to an address to a previously verified signature as completely different, a universe apart from handing a person a ballot that has no verification they are entitled to even possess it. Your Honor, through the process that the auditor's office has, I can obtain your ballot. And I would ask you if that's appropriate. The auditor has nothing in place to stop me from picking it up at the replacement ballot process. If you were to call and request your ballot be replaced, it would be mailed to your place of residence. That is in itself a security measure that the legislator had in place. They do not have the security measure of handing people the property of the people, the votes of the people, freely and willy-nilly, like it doesn't matter. The auditor would have you believe they could have a stack of ballots sitting in the auditor's office, and you would simply come up and ask them, which pile do I pick the ballot out of to be able to take away with me? That's not how the vote-in system works. It's completely laughable that is a position they would like the court to believe is existing because it's so far from reality. The remote affidavit, I can't be any clearer. Affidavit processes are used regularly every single election by people remotely from around the entire world. This is not inhibited or changing anything that's in place. I would also laugh at something else that I heard be repeated now multiple times, that there's no specific law to require signature verification of a replacement ballot. That's the wording that the auditor's office is placing into the court. Well, there is signature verification required all the time. And I would say a parallel of the same situation is somebody saying, well, I'm going to go ahead and hit you in the head with an axe on a Tuesday because there's no law against that. Well, you're right. There's no law against that on a Tuesday. Well, it's assault. And the same thing in this voter situation. It's against the law to issue a ballot to somebody who hasn't provided evidence and hasn't been verified. The legislative process to verify identification in our voter system is a signed affidavit. That is it. What the court is being asked to do is to override the legislature and to completely destroy the verification process for our ballots in this county. I consider that just insanity. I would speak back to the original statement that opened this up, and I will just take it at, without insulting Mr. Peterson, his statements, whether they were intentional or not, the video can be replayed. I did not claim to have previously have voted. His statements were rational. They aren't based on anything I think he can substantiate. The video of me getting replacement ballot is consistent. I told in the primary that I had not received my initial ballot, and in the general election that I had received it, but I could not find it. What I find interesting, and I'd like to point out to the court right now, I was never asked, did you fill it out and sign it? That's in this general election. I just couldn't find it. And so it seems appropriate to tell people, hey, what's the situation? Did you lose it? Did you fill it out? Did you sign it? Because the signature affidavit is the most critical part, and then explaining to the voter what's going to happen next with the replacement ballot. That, yes, it'll be the first signed one that's received. Again, as a bigger picture, Your Honor, I have to just stand back and say the legislature has many safeguards in our election system. Regardless of whether you believe in the system or not, it does have some. One of which is the possession of election material and ballots. It has made it a criminal act to improperly distribute those materials. I find it convenient that they would like to ignore what I initially brought up. The auditor doesn't have the ability they are not legally authorized to freely distribute this material. They are required under the statutes to verify the identity of people. They have signature verification outlined by the legislature as the means to do that. This is, until it is released to the proper voter, this is the material of the government and the public of Skagit County. This is our property. We require it only be distributed to the people who are legally entitled, which is the registered voter, or in certain circumstances, spouses. I agree with that, but there's a legal process to prove that. The possession of this property is not authorized under the law. And I, as a Skagitonian in a Skagit County election, who has found out that there's considerable amount of my funds being willy-nilly handed out to people without any justification, you might as well go in and ask people for the monitor on the desk and the stapler on their desk, because I want that. That's mine. I would give that parallel as well. Besides the security protocol that with every ballot that goes out that isn't in the proper hands of the right person, we are opening our system up for fraud. That is why it is in person. You must verify a signature affidavit. Your signature affidavit has to be verified to mail it to your house. I can't be it's more repetitive. The legislature couldn't be any clearer on it. Thank you.
Thank you very much. Folks, we're going to take a 10-minute break, and then we'll come back and we'll decide whether our issue of ruling today or whether I'll come back at another time. So we're going to take a break until 4 o'clock. Thank you.